Time to talk law. This is Radio 97. Our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay. With us each and every Thursday morning at this time. Make sure you put it in your diary. She's here to offer her legal expertise. She brings with her some general advice on the latest of hot topics and your questions too. She's got experience that spans more than 25 years in the area of property and commercial law. She also prepares wills as part of estate planning and litigation. With us once again. Morning, Despina.
Good morning, Wayne. Good morning, Brooke.
Good morning, Despina. Good morning, Wayno. Another day and talking law hitting hard this morning. In this particular chat, we're starting off with a bit of a fun one because each Thursday, obviously, we talk through lawsuits, buying property, a bunch of different topics. But at times, we might hear some key words or phrases that could possibly be maybe a little bit confusing, or we assume we know the full definition and how it all works. And in reality, we actually don't. So, Despina, we thought this morning we'll go through one of the most popular phrases that you might hear on Talking Law and get you to break down basically what it means and give us some examples. And this particular phrase is under contract. We've heard it, and hopefully listeners don't turn off. I know some people might think, I know what that means, but there's a few things I think with under contract that we don't quite understand. So, Desi, if you can talk us through what is under contract, how does it work?
I will. And I think we can all continue to learn, can't we? About lots of things in life. And it never ceases to amaze me that clients who we've acted for many times still sometimes can't, or maybe they don't understand these basic concepts, which are important because the basic concepts forms the foundations for legally binding agreements between other parties. And that binds you to certain promises that you might have made in that agreement, which may not be what you've intended. So we want to talk about what does under contract mean? It sounds pretty basic, but let's go through it because I'm pretty confident the listeners will probably discover a few new things out of our segment this morning. So what does under contract mean? So people use it all the time. Are you under contract yet? So let's be clear, and we'll talk about quite a few things. So when someone generally refers to what does under contract mean, the general inference you can take away is that is a party bound to a contract? Okay, so is the party under contract, meaning are they subject to a valid contract that they've now got to perform under? Yeah, and they've got certain rights and obligations that they've got to perform like the other party does. So we all want to know, what does that mean and when does it start? Because you want to know when your obligations commence. So you make sure that you do perform and that you don't breach and fail to perform your obligations. So it takes me back to I suppose, some of the basic concepts which are very important in the fundamentals of what is a valid contract. So people understand some elements to a contract and what's a valid contract, so they can understand what we're talking about. So basically, you've got three main components. You've got an offer that's made to one party to another. Then you've got that party that would need to accept that offer. And then you've got what's called consideration. So those are the three main elements: offer, acceptance, and consideration. So sometimes clients say to me, look, here's a contract. I've accepted the offer, but I'm not paying any deposit. And so I say, why is that exactly? You really can't get away with that. If you want the contract to be valid, you've really got to pay a consideration, a deposit. It doesn't need to be a substantial amount. It's got to be an amount called consideration. Okay, so there needs to be some benefit passing. So there needs to be a deposit paid. So that's really, really important. And even today, I've got clients who say, I'm not paying a deposit. And then I have to explain to them this concept that, well, you really do have to pay some form of deposit. So that's really, really important. And then that leads me to talk about other things such as offers of intent or letters of intent or expressions of interest, all of the other sort of paperwork that might come in the listener's way from agents or from marketers where they're interested in buying property or even a motor vehicle, or could be just chattels that they want to buy. And it might not look like a formal contract. So you go and sign away thinking, oh, well, it's just an expression of interest. It's not binding. Well, you really have to be careful because it might actually be binding. Okay, because it comes down to what's in that document. So when we talked before about offer, acceptance, consideration, those are the three main elements. But there's also I suppose, intertwined in that, the court would look at, well, what was the intention of the parties when they signed, when they signed the paper that we're now fighting over, whatever the document looked like. What was the intention? So you go to what's in that document. What does it actually say? And some of these letters of offer or expressions of interest, some of them do say that whatever option fee or holding deposit, whatever you pay, an expression of interest fee, sometimes they say it's non-refundable. Most of the time it's refundable, but sometimes they say it's not. So that's why it's really important to read everything in the document given to you. If you see a word, for example, in an expression of interest document that says, or any fee you pay is non-refundable, you want to cross that out, because the idea is you shouldn't be bound to just an expression of interest, because an expression of interest should always be non-binding, because it's subject to the parties entering into a formal contract.
Yeah.
Okay. And the formal contract is going to spell out all of the terms and conditions that an expression of interest form does not contain. Okay. And usually that document does say subject to entering into a formal contract. But say if it didn't, say if the expression of interest didn't say that, and it just had some terms like, here's the price, here's the deposit, it's 30 days, this is what's included in as part of the deal. And say if it didn't have that wording, that it's subject to the parties entering into a formal contract, well, then definitely there's a very good argument that the person who signed, like the buyer and then the seller, they're bound to that expression of interest form or letter of intent. And it may not be what you want, and it may have missed out on really important elements of what you're buying and what you're selling. Yeah. So the point being that you should always have your expression of interest or letter of intent, whatever it's called. It's usually a 1 or 2 page document, always subject to the parties entering into a formal contract that each party accepts. Yeah. That each party accepts. So say if the party gets a formal contract and they don't like it, say if the one party puts in there a very onerous obligation that you didn't expect, well, you don't want to be bound to have to sign that contract, do you? Yeah. So it's really important to have those I suppose reservations.
Yeah, so it's moving from one stage to the next. Now, you talked about the deposit. Is there a minimum for the deposit? So can I give you $1 and that's the deposit paid? I mean, is there an absolute minimum?
Sure, you can do that. You can pay $1 or $10 or $50. I don't know if the seller would accept that, but I don't think it's usual practice to do that in transactions. But sure, that is consideration as long as you've paid it. So, the contract has to say that that's the consideration, but then it's got to be paid. So the benefit's got to pass from the buyer to the seller. So that's got to happen as well.
So there's no minimum. So it's not $100 or $1,000 or whatever.
That's right.
Percentage.
A percentage. Yeah.
There's nothing in the law that says that, but normal, usual commercial practices are that you will pay, a reasonable fee, which there is an argument that $1 isn't really a reasonable fee because if the buyer does the wrong thing, you've only got $1 for your trouble. So, that's why it's not set in stone, but usually the minimum is 1,000 or 2,000. It's not set in stone by law, but that's the usual practice in contracts. But yeah, really, really important for buyers to take away from today about what does under contract mean and what are the consequences of that. So as I said, you've got your offer, your acceptance, your consideration, 3 basic elements. There are other things to forming a valid contract as well. For example, what if a party wasn't capable of signing? Say if they were under 18, or say if they were not of sound mind. So you've got that element as well to make sure that the parties were capable of actually understanding what they were signing. So that's really, really important. And of course, the intention to actually create the binding contract. So what are we actually doing? Are we just signing a document where it says, well, this is just an offer to put it out to you, but we intend to formalize it later? Or is this intended to actually be the the formal contract right now. It's really important you read that. And if the document is silent, say if it doesn't say anything about, well, we're going to enter into a contract later, or this is subject to us entering into a contract, you write those words in. So you actually write by hand, this offer is subject to me signing a formal contract that I am happy with, that I'm satisfied with, and my lawyer is satisfied with. So if there was ever a dispute, you could front up to court and say, hey, it was never my intention that I be bound to buying this item, property, chattel, whatever it is, because I signed a one-page document. It was always my intention to just, hey, can you hold this? This is my expression of interest. I want you to hold this item until we sign something that I'm happy with, a more formal contract. So it's really important. And as long as those words are in, it's super, super important. And these are the fundamentals that go back all the way to 1954. It's a very famous case, a high court case in Australia called Masters and Cameron. People in the legal industry will know exactly what I'm talking about. And that has always set the foundations for what's a valid contract. And there are all these elements that go into it. So hopefully that's given some people some insight into what does under contract mean, and maybe they can take away some things for the future.
Definitely. Thank you so much, Despina. And coming up next, private school parents and or guardians. This next story is for you, and it's a juicy one. Stay tuned. You're listening to Talking Law on Radio 97.
Are you confused about legal jargon? Do you need legal advice but don't know where to turn? Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97. Despina, a leading lawyer with over 20 years of experience, will demystify the law and provide practical advice to help you navigate legal issues. Whether it's a family matter, a property dispute, or a business concern, Talking Law has got you covered. Don't miss out on this valuable resource. Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97.